believe we have a quorum, so camera's rolling, so we're official. And I call this meeting in session. I assume everyone has received the minutes of the last meeting. If there are no comments, corrections, or additions to be made to it, I ask for a motion to accept the minutes. And I think it's unanimous.
I abstained.
When I wasn't here.
Mr. Gaval doesn't, abstains rather.
And Ms. Bauer.
And Elizabeth Nauer. And I still sound weird on this microphone.
Not to us.
Oh, okay. I'm just getting weird feedback over here.
You sound fine down here, right?
Yeah.
You sound fine, no problem.
Why are you all the way down there? Every other meeting you've been up here, and you're trying to get confused.
I don't want to sit next to you.
Oh, they told you about me. Huh?
Yeah.
At the legal bureau. There is a Department of Sanitation proposal concerning recovery of refrigerants from appliances. Is Ms. Cooper here?
Good morning. Good morning. The Department of Sanitation is requesting a change to its penalty schedule to allow us to issue violations pursuant to Local Law 69 of 2013. In August of 2013, Local Law 69 was enacted, making manufacturers or brand owners of refrigerant-containing appliances responsible for the lawful recovery of refrigerants from their appliances when such appliances are discarded by city residents. These appliances are things like refrigerators, air conditioners, water coolers. While manufacturers and brand owners, defined as responsible parties in Section 1701 of Chapter 17 of Title 16 of the Rules of the City of New York, will be responsible for the recovery of refrigerants from their appliances. DSNY will continue to provide its own refrigerant removal program, in which DSNY will charge a fee to the manufacturer or brand owner for every appliance from which it removes refrigerants. It's important to note that this law does not change the way homeowners dispose of their appliances. Homeowners can choose to avail themselves of DSNY's program by calling 311 or making an appointment for refrigerant recovery on DSNY's website. If a responsible party creates its own program, such a program will be listed on DSNY's website and a homeowner may choose to use that program instead. There are no penalties for homeowners associated with this law or the rules promulgated under this law. Local Law 69 of 2013 granted DSNY broad authority to promulgate rules as necessary to implement the provisions of the law, including but not limited to rules regulating to registration and annual reporting by manufacturers or brand owners, and establishing penalties for violations of the law and rules. Pursuant to this authority, DSNY promulgated rules that establish registration and annual reporting requirements for responsible parties of refrigerant-containing appliances. The rules establish the fee at $15 that a responsible party must pay if refrigerant is removed from its appliance by DSNY. And the rules establish violations and fines for failure to comply with the rules and the law. The rules set forth the fine amounts as follows. Responsible parties that fail to submit a registration or annual report will be subject to a fine of $250. Responsible parties or their agents will be subject to a fine of $500 for improperly releasing refrigerants into the air. Responsible parties or their agents will be subject to a fine of $500 if they dispose of any appliance as solid waste in the city without making arrangements for the lawful recovery of refrigerants. I'd now be happy to answer any questions you might have.
In the schedule, the penalties are, and the default are the same amount?
Yes.
Is that because the law doesn't allow for a range, or it just seems like that would not necessarily encourage people to not default? Like, how come the defaults are higher?
Madeline LaGuardia, Sanitation. The full penalties don't necessarily need to be higher than the initial penalty, and because we promulgated the penalties in the rules, we felt we needed to have a fixed amount.
Okay. I mean, you're not worried if people are going to default?
These are manufacturers. These aren't just normal citizens. This is the cost of doing business for manufacturers and responsible parties.
And the manufacturers have been very involved in every step of the process, from the enactment of the law to the creation of the rules, so they're aware of the fine amounts, and they've been very involved in working with us, so I don't expect that we should have problems getting them to pay if they're issued a violation.
Jorge Martinez, DOH. For the violation description of 16 RCNY 17-06, the responsible party failed to comply with federal regulations regarding refrigerants. What federal regulations are being referred to?
It's the Clean Air Act. So the Department of Sanitation is under an EPA consent order to make sure that they don't vent refrigerants into the air when we dispose of refrigerants. That's why we run our refrigerant recovery program. We are responsible to ensure that it doesn't happen, and so we are holding the manufacturers to the same requirements we're held to.
What about automobiles? Or is it the stuff that they're using in automobiles now, different than what's used in refrigerators? We cover refrigerators.
The department doesn't pick up.
We don't, right.
Automobile
Appliances.
It's just appliances, these are just appliances that the department picks up
Those
from
just
residents.
pick up.
Yeah.
Yeah, I just had a quick question. I just want to understand a little bit. See, if I have a refrigerator,
Right.
regular red West,
Yep.
and I want to put this out on the street, I must either contact the manufacturer there, whoever, and they would come and drain the refrigerant, or, and they use DSNY's $50?
No, the homeowner is not paying anything. The manufacturer or the brand owner. So
Okay.
Frigidaire would pay us if we recovered the refrigerant from your appliance. But right now, if you put the refrigerator out, you have to call 311 or go on the department's website to make an appointment. That's been a requirement for
Okay, so the
at least 10
violation is
years.
not calling you.
No, the violation has nothing to do with the homeowner or the resident. It is only pertaining to the manufacturer or brand owner.
Right, I think you have to do that anyway, right? Because
Correct.
when the refrigerator away, you have to go inside for it.
Correct.
A special truck, yeah.
And you guys are only charging them $15 for you?
$15 per appliance. So if they have 1,000 appliances,
Of course, it's paid up front.
But they would never come and do it themselves.
they may if they create their own program, and we expect many manufacturers will partner with retailers. For example, PC Richards has a program now where they'll take your appliance away if you buy a new one.
Any other questions? Is there a motion to direct the staff to publish under the CAPA? It's unanimous. Thank you. Well, sanitation, of course, abstains. We have a proposal concerning changes to ECB procedural rules. James?
Good morning, everyone. James Armstrong, Law Fellow, the General Counsel's Office, and today I am presenting an ECB proposal with two parts. So I will go through each part in turn and then see if there are any questions of these. First, ECB proposes to amend sections 48 RCNY 3-57, 3-71, and 3-73 of its rules of procedure. These proposed changes would allow ECB to serve hearing officer decisions and orders either by mail or by hand delivery. The current rule, 48 RCNY 3-57, requires ECB to serve decisions and orders in all parties. However, the rule is silent as to how they are to be served. Currently, ECB serves via mail. However, to promote efficiency and flexibility, ECB proposes that the rule be amended to allow both mailing and hand delivery of the decisions and orders. So the amendment to 48 RCNY 3-57 also requires amending two other sections, 3-71 regarding exceptions to decisions and orders, and 3-73 regarding payment of penalties related to decisions and orders, because both of these sections currently only refer to mailing. That concludes the first part of the proposal. I continue now with the second. ECB proposes to amend 48 RCNY 3-91 to allow for service of cease and desist orders and notices of special hearing by regular mail. So since DEP also serves these orders on respondents at addresses where the equipment is located, certified mail service is not necessary. ECB records also show that many of these mailings actually are returned to ECB because respondents don't go to the post office to pick them up. And finally, if equipment is sealed due to failure to appear at a pre-sealing hearing, then ECB rules provide for a prompt post-sealing special hearing. That concludes the proposal. Are there any questions?
Yeah. Russell Piccioni's Department of Environmental Protection. So right now, I get a number of times a week a big envelope in my mailbox full of decisions. And I'm assuming that for the respondents, they will continue to get the decisions by mail. I mean, you're not proposing to send somebody to the respondent and serve them personally
No, the
with the
way
decision.
it would work is, after
Amy
the
Slifka?
hearing. Yes, Amy Slifka. After the hearing, the hearing officer will ask if they wanted to wait for their decision. So instead of having to wait for the mail, they'll have the opportunity to get their decision right away.
Oh,
after
so
the
people
hearing.
will now be able to opt to get the decision on the spot?
Correct.
Oh, okay. And so will that change the way the agencies get the decisions, or
The agencies are still going to be getting it by mail.
we'll still get it by mail?
Yes.
Oh, okay. So this is a change that affects the
Right,
respondents,
to
not
help
the
to
agencies?
assist the respondents and
Okay.
make it more user-friendly.
The idea behind the rule is to eliminate the incongruity that someone could come to a hearing and we didn't tell them what the decision of the hearing was and tell them to go home and wait for the mail to come, where we could have told them just as easily right there. Not to mention the fact that we would save an immense amount of money on postage. Our postage budget is $1.1 million a year.
When it says hand delivery, what is the standard to show that it was actually delivered? Is it going to be like service?
Yeah, it will be
Same as service?
Correct, and we'll have an affidavit, that the clerk will fill out, the customer service will fill out when they hand to assure that it has in fact been handed to the respondent.
And if no one is there to accept it by hand? are we
It will be
gonna
mailed.
have- Then we just go.
So some people might not want to stay for their decision, maybe they have to get back, the child is being raised, their parents, we're not going to force them to stay, but they have that option.
Sorry, I forgot to say my name, Ernest Cavallo, citizen member.
It's Ronaldo, Department of Living. I have a quick question about logistically how this would work. I mean, is this going to be for all the cases, first of all?
Essentially, yes. This is the same thing that's been done at the Taxi and Limousine Tribunal since forever. Hearing officer renders a decision, the respondent waits outside, and usually within 15 minutes, they get their decision handed to them.
And then, because I know,
Just for your information, we started to pilot it. We piloted it in 3 boroughs right now, basically with sanitation at this point in time, and it has had very little, if no impact on the waiting time, if you're concerned with those issues.
yes, I was going to bring that up because I know in particular, in my agency, our cases are a little bit more in-depth sometimes, building cases, and they take some research that the judge may want to do and so on. So I'm wondering how long, how is that going to push the calendar to infinity? I mean, it seems sometimes we have a very crowded waiting area for building cases and building days in ECD, and wait times are already up to, I think, maybe over 2 hours. So just to hear the cases.
Well, if that's the case, then that's a different issue we have to look at, because it shouldn't be taking that long. There's a scheduling issue there. But we can talk about that. If people are waiting 2 hours to past the time that a hearing was supposed to start, that's not right.
Would Russ Piccioni again, DEP? Would this be something that the judge would have the option to not offer if it's a particularly busy day, or if it was a particularly complex matter that they felt like they couldn't, like the person might have to wait 4 hours before they write the decision? Would the judge have the option to not offer this in certain situations?
The hearing officer can always reserve decision.
Elizabeth Nauer, citizen member. I actually had a question about the rule, not the amendment. So if it's all right, in terms of mailing, where I guess if the respondent declines to wait or if the option isn't available for reasons that Russ just suggested, I think that the rule says it's mailed to an authorized representative or the respondent. Does the authorized representative include the Secretary of State?
No, by authorized representative, they mean the person who comes in on behalf of the respondent.
Okay, so it's always
Yeah.
mailed to an actual
Correct.
person connected.
Correct.
Okay, I just wanted to make sure.
Secretary of State, you can only mail it to them for the initial service that initiates the process.
I had a question about the other half, the cease and desist. For the service, I think we talked about this last time, because you guys personally delivered the cease and desist order, and I think the option of certified mail before was if you didn't personally serve it, but from what we talked about, you did both, and that was why we were looking for regular mail. But here, this is now saying that you could do personal service for regular mail, and I feel like the gravity of the cease and desist either warrants certified mail or personal service, or if you're going to do personal service and regular mail. I don't know if I'm making myself very clear. Like, regular mail is the only point of getting this to somebody. Doesn't seem sufficient to me for a cease and desist order. Anybody else?
I mean,
I thought that was actually what we discussed last
That's
time,
what we-
because I thought this was put before us on a larger amendment to the rules, and then this was deferred for further review, because we talked about having it say regular mail and personal.
I know there were other issues, I don't remember this particular, because they were focused, I was focused on other issues that
Mhm.
you raised, which were not brought here. You do always.
Yeah, the
personal
standard
service.
policy has always been that when we get the orders from ECB, that they're given to inspectors and that we have inspectors serve them, and that you also mail them.
Right.
So they're doing a mail and mail, and
not a mail.
Yeah, we serve them the same way we would attempt to serve any other, process. I just think the point here, and DEP, since we're the only one that have cease and desist orders, I mean, we're not opposed to this. We understand that certified mail is very expensive and also is not necessarily more effective in getting the thing through to people, because if they're not there to sign for it, then they get a little card, and half the time people don't go to the post office. Whereas regular mail, it gets left in the mailbox whether anybody's there or not, so.
I guess I disagree with the gravity of the order, that it should either be personal service and regular mail, or it should remain personal service or certified. Because at least there's a record of you having attempted to send this to them.
The only value of certified mail is that you have proof of, some kind of proof of mailing. And if the person bothered to pick it up, you have proof of receipt. Legally, service is good the moment you mail it, or within 5 days after you mail it, regardless of whether the person in fact got it. That's what the law says. We want to be sure that the person actually gets it, and the reality is, if I send you a letter today by regular mail, you'll probably get it within 2 days. If I send it to you by certified mail, you'll be lucky if somebody knocks on your door within 5 days to deliver it. And then if you're not home, then whenever you have the misfortune of having to go to the post office and stand online for a half hour to pick it up, or bother to do that, then you'll actually have the mailing in your hands. And then we get the benefit of saying, yes, she got it. Here's a little card that says she got the envelope. Of course, that doesn't mean that the envelope wasn't empty, but that you got an envelope.
Just to follow up, why can't we have, I mean, I thought that what was going to be reviewed was the idea of having it say and rather than or, so that we would have, it would be personally served as well, which apparently is the practice, so is DEP opposed to having the rule require what it in fact is putting into practice at this time?
I mean, we do it anyway.
Yeah,
so
I mean,
think we're
if they do it anyway,
neutral
the
on that.
and, we're gonna mail it also, so if they put in and instead of or.
It's
So
true.
it's gonna be person served and
We-
mailed,
We're talking about preclusion orders.
so, yes.
Sealing orders.
Yes, correct.
Cease and desist.
So from our standpoint, we have no objection to changing it to and also, so we can change it to and.
Neutral on that, we do it anyway.
So
I-
with,
My only issue there is if the city's already sent out an inspector, which costs the city money, to serve the document, and the inspector has followed essentially the CPLR procedures for serving a document in person or mail and mail. And we're wasting a lot of money.
no, it'd be regular mail.
It's still money. I mean, it's a difference between spending $5 for certified mail and 50 cents just for the postage.
We want to just delete the mail.
Right, and I think the issue is making sure that personal service occurs, not,
The object of the exercise is that the person is aware that the order exists. That's the object of the exercise, and I can't imagine any more effective way of telling somebody than to walking up to them and saying, here's the order, shut it down, or whatever it says.
so, but if the rule says or, that means that it would be complied with simply by a regular mailing, which is, I think, the concern Emily was raising, which I concur.
So you'd be happy to just say personally, period, and no mailing?
Or personal or. Personal, yeah,
Personal and
Right.
or just personal.
yeah, personal service is best, obviously.
I mean, half the time the mailings, well, not half the time, but a lot of the times the mailings come back now and it's still considered that they've been validly served because it was sent to the right address, and if they didn't get it, if they didn't go to the post office to pick it up, then it's still considered validly served.
But on,
Even if we don't send an inspector, it's still considered validly served.
but on these cease and desist orders, because of usually the gravity of what's going on, is it the normal practice to send someone?
Yes.
Perhaps the rule should simply say personal service.
Right.
So we take a straw vote on that?
Quick question first.
Sure.
Tom Specker, citizen member. Go to personal services, I mean nail and mail is no good. I just want to clarify that before we.
Well, the one thing I think we would object to is if we have to get in the business of mailing these things, because we don't always get them from the board, especially if there's a lot of them at a given meeting. We don't always get them at the board so that we can do like a full service thing ourselves. If there's going to be mailing required, I think we would take the position that we would like the board to continue doing that part of it. I don't think we want to be solely responsible for affecting service. We're willing to send an inspector to the building, but I don't think we're willing to get into the business of starting to be responsible for mailing these.
I'm just thinking of the bureaucratic process. It would require some kind of a feedback loop from DEP to ECB that it has to be mailed, and that when you start adding complications like that, that's when mistakes start to happen. things that sometimes fall between the cracks and like that, so.
Dan Albano from Police Department, is there a way of slicing this up, that cease and desist orders, which apparently the most important, that they follow one method, and would that satisfy you guys?
Yeah, I think that's the way it is.
Yes, it is. It only applies to-
Only applies to cease and
Yeah.
desist. The decisions go out. If the decision goes out by mail, it just goes out by
It's
mail.
not the decision, it's the order itself.
How about changing the proposal to say that it be personally served and sent by regular mail?
And that's what you originally.
That's what that's where we started.
And
I think the volume is not so great that the expense would be more than it.
That's right, the balance.
It's not every,
so, yeah, I'm sorry.
I have just to go back away from to your regular decisions. Your original concern that I had, I have another concern about the waiting for decisions, especially when it relates to few of the cases where I wonder how this would impact on the quality of decisions. If the judges felt that they had to rush to get a decision out, I wonder how much could be overlooked. You have time to really sit down and contemplate the decision before they write it.
Our hearing officers will continue, they're not, the decisions aren't going to be less or worse because they have to write it the same day. And again, the commission already said they will have the right to reserve decision. So if it's a complicated issue, they can reserve the decision. But I don't think anything will be lost by it. I'd like to think the quality will remain the same.
Or we'll fire him.
Ernest Collis is a member. It really gives the hearing officer an option.
Correct.
And I would think that they would continue to do what they've been doing, but if they know that, okay, I know what this case is at the end, and frequently as a judge, you do know as soon as the last witness has gotten off the stand where you're going to go with it, and you can just write it out. It just gives them the option of handing it to them right then and there, as opposed to, I really should think about this, but I'll just hand it out. I don't think most judges would do that. I think they would continue to reserve
And in addition.
and consider.
Right, and in addition, there is some downtime because sometimes the hearing officers are waiting for reps. This is why they can't go forward with the case, or an inspector. So they have that time in between where they can write up decisions. So I'm not too worried about that type of issue.
Thanks for taking the pressure off.
So shall we change the draft to reflect that it shall be served personally or personally and regular mail?
And that's a considerable savings.
It should be. It should be.
And time, there's a lot of work going into doing the certified mail, filling out forms and all that, so, yes.
It's a manually intensive process. Can't automate it. At least Whitney Bowes hasn't told us how they could automate it. I'm sure if they could, if they had a machine for it, they'd be happy to sell it to us. Can I have a straw vote on it? All in favor?
On the end?
On it's saying, the notice of special hearing shall be served personally and by regular mail. Okay, I think. Is there anything else on this proposal? So, is there a motion to direct staff to publish as we have amended draft? Seconded? And I think it's unanimous. Thank you. That was good. See, democracy works sometimes. Kind of, sort of like. Dana Haynes will give us a presentation on the final rule regarding amendment of the DOT penalty schedule.
Good morning. This is a DOT final rule proposal based on a presentation originally given by DOT regarding increasing the penalty for failure to protect worksite from $400 to $1,200, which is still well within the range. The maximum penalty allotted for is $5,000. The rule has been certified by Law and Ops and was published in the City Record on January 12, 2015. Public hearing was held on February 11th. Two members of the public attended. Neither gave any testimony regarding the rule. We also received one written comment from National Grid. The hearing transcript and written comment have been provided to the board for review. Are there any questions?
I have one question about the written comments, and it says 109B is only at $100. Is that even a similar charging section? Or is
It
that
is
related?
it's subsection B of the rule, and it's regarding the actual signage, whether their signs have been posted.
Okay. So, I mean, is there a scenario where you might charge for under one and not be at like, would somebody wind up with a $100 fine versus the $1,200 fine for the same thing? I guess that's what I was wondering about, and how the enforcement actually happens.
Could you speak up because we
I'm
have
sorry.
some-
Good morning. Hi. For the 109B, it's $100, and this other one's now $1,200. So could two different respondents wind up with a wildly different fine for the same condition, or is how's the enforcement done, I guess
No.
is my question.
The Department of Transportation has a standard code that we use. We do not use different codes for the same infraction. And as a matter of fact, I'll review the penalty schedule to be sure that we don't have two different codes.
Okay.
And if so, come back and ask you to do it. That was Shamanda Brown. I'm sorry, Shamanda Brown, DOT.
Follow up with the comments. It sounds to me like Corey Martinez George, that you could on these increase the amounts go either higher or possibly lower. How did you calculate 1,200 or 3,600? How did you arrive at those specific amounts?
When setting the penalty amount, the department reviews the current penalty schedule to find similar infractions in nature and try to give it a penalty that's similar to those that are already set. The default penalty is always, mostly when we can, when it's within the maximum allowable amount, is always 3 times the original penalty. This one was chosen based on our other safety-related infractions, such as failing to pin and ramp steel plates, things of that nature, and those fines are $1,200, as well as stipulation violations.
Any other questions? Comments? Is there a motion? And I think it's unanimous. To approve for final publication. We now have introductory presentation for the final rule regarding amendment of sanitation penalty schedules for recyclables.
And this final rule is based on DSNY's initial proposal regarding bulk collection of recyclable materials by motor vehicles. It's a technical change to amendments made to the sanitation penalty schedule in 2014. And the purpose of this rule is to restore the intended purpose of the law to apply to vehicle owners, not just operators of motor vehicles. Again, this rule has been certified by Law and Ops and was published in the City Record on February 11, 2015. A public hearing was held on March 13, 2015. Nobody from the public appeared or gave testimony, and also no written comments have been received. Are there any questions on this rule?
Is there a motion? I believe it's unanimous, except for sanitation abstains. It can be published for final inclusion in the city's regulations. Or actually, the city's rules. After the charter was amended last time, the city of New York has no regulations, only rules. You introduce ECB requests for pre-sealing reports. I'm sorry, I missed one. Cease and desist orders by DEP.
Good morning. Russell Picunis, Assistant Counsel, DEP. This month, DEP is making one request for a cease and desist order under the noise code. This is for University 10 parking, which is located at 63 East 9th Street in Manhattan. This is a parking garage. They have been cited on 3 occasions for excessive noise from their exhaust fan. And due to the repeated violations and continuing failure to come into compliance, DEP is asking the board to issue an order to cease and desist.
Any questions?
Is this going to be no?
Not yet.
You know, can't be. Get an injunction.
That's still under the existing rules.
I wish it was cease and desist laws.
Yeah, right.
Is there a motion? It's approved. With the DEP abstaining, of course.
Next, we have 16 requests for cease and desist orders for failing to renew certificates of operation for boilers, which are currently certified to use number 6 fuel oil, which is prohibited as of June 30th. In each of these cases, the owner or managing agent has been found in violation of failing to renew the certificate of operation, and due to their failure to comply with the order to renew, the department in each of these cases is asking the board to issue a cease and desist order.
Yes.
Tom Spetner, citizen member. Can you just walk us through what happens procedurally after the C&D is issued? Just, I know it's going to be summer, but you know the ultimate result could be to shut off the boiler. So can you just remind us what has to happen in the interim?
We've been asking the board for these for a little bit less than a year now, I think. And in that time period, there are currently a total of about, I think, a dozen or so respondents who are in default as to the cease and desist order. So over all of the ones that the board has approved in the last year, it's a very small number of them that are in default. We have not sealed anyone yet. And in fact, we will not seal anybody if an inspection shows that they have in fact converted to an acceptable fuel, but have just failed to do the paperwork to get the certificate of operation. So if we know that they've converted to number 4 or number 2, even if they've defaulted on the cease and desist order, we're not going to seal them. But when the weather gets warm enough this spring, for those that we know are still using number 6, for those that are in default, we will make a last attempt to reach out to them by sending an inspector to the building, and if it's a managing agent, to the managing agent's offices. If all of that results in still no response, then in the spring we will start sealing boilers.
Are any of these residential buildings?
Most of them are residential buildings. That's why we're waiting until it gets warm enough, so at least it will be an issue of mainly no hot water instead of no hot water. And the building will have to get a temporary boiler to provide that until the boiler is unsealed.
Elizabeth Powers, citizen member, the board would still have to approve the sealing order
If
before
they're in
that.
default, the cease and desist order says we can seal with no
Oh.
further action from the board.
It's self-executing.
Can the house owner or building owner appeal any of these orders?
Well, they've already been found in violation, and the decision, when they're found in violation, includes an order from the hearing officer to comply with the code within, depending on which section it's issued under, within either 30 days or 90 days. So if they've failed, the cease and desist order is based on the respondent's failure to comply with that order from the hearing officer, which if they don't appeal it, becomes a final order of the board. So that's what it's based on.
Any other questions? Is there a motion? And I think it's unanimous except for one abstention.
And finally, we have 27 requests for cease and desist orders for failing to install backflow prevention devices. And these are pursuant to the same normal situation as the ones that we bring every month.
Any questions? Is there a motion? Is buildings holding? And it's unanimous with one abstention.
Thank you.
Thank you. Now we're going to look at the preceding reports by Kelly.
Good morning, we have 22 preceding reports from the board. 18 of those pertain to backflow violations, one pertains to a sewer code violation, one pertains to an air code violation, and 2 pertain to noise code violations. Regarding the backflow violations, in 17 of those cases, the hearing officers recommended that there be no sealing or other action given the respondent's compliance, or that the C&D orders be discontinued because the respondents no longer own the site premises. In the last backflow case, the hearing officers recommended that the C&D order be discontinued based on the respondent's evidence that the water lines had been sealed and a demolition permit had been issued for the site premises. Regarding the sewer permit, the preceding report for the sewer equipment, in this case, the hearing officer recommended that the C&D order be discontinued because DEP records had shown that the cited restaurant is out of business. The air code case, we have one sealing report for an air code case. This pertains to the respondent's boiler burner. The respondent's representative provided proof of a valid operating certificate in bringing the boiler burner into compliance with the air code. So the hearing officer recommended, no further action given the respondent's compliance. And the final cases are the noise code cases. In both of these cases, the respondent's representative provided proof that upon inspection by DEP, the equipment is now in compliance. Based on the evidence of that compliance, the hearing officers recommended that DEP inspect the equipment and that the equipment remain unsealed if the reinspection shows no violation, and further re-inspections show no violations for a period of 180 days. Any questions?
No questions? Is there a vote to accept? It's unanimous with one abstention. Thank you. now request, is there a motion to go into executive session? And it's unanimous. The board will now go into executive session, which means that all all personnel who are not members of the board or employees of the Environmental Control Board or oath, please leave the room until we return from executive session. Executive session where we have reviewed some judicial decisions, reviewed some appeals cases, and the status of some litigation. Did you have any appeals cases presented? Is there a motion to affirm the appeals decisions from the March 5 and March 19 appeals panel?
Okay, so I was asked this question, I was on that panel.
Yes.
Oh? Yes.
It's unanimous. Is there a motion to adjourn? We are adjourned. And for Emily, the last time.
I'm going to